What's up, guys? Aaron Bennett here. I'm going to play about 13 minutes or so of David Adler talking about claims on a January 24th Twitter Spaces. It's super important that you listen to the entire thing. For one, if you decide to do an additional claim for fraud and whatever, it supersedes your existing claim, so you must include your coins or your entire claim could be wiped out. Now, for myself, I have personally decided I am not going to be submitting an additional claim. I may regret this. There may be a lot of money that can come out of it if you do. I don't know. I've heard both sides. I've heard the side from David saying that everybody should be submitting a claim, but there's a lot of people that are not technical or should not be probably messing with this stuff without a lawyer watching them, making sure they do it correctly. And that's something that I'm very, very aware of. I am not suggesting you do anything other than what the hell you want to do, because if you mess up your claim, it could really be devastating. You could be in court for a long time. You could have your claim be denied and then have to literally appeal it or whatever, go to court, and then they could deny your claim there. There could be a lot of extra headache. It could take longer for you to get your coins out. So I've heard both sides. I just want to complete this conversation giving you David Adler's latest thoughts on this. So here we go.
So without, providing unpaid legal advice, but helping us out here, what would you suggest, prior to actually seeing the examiner's report, that like the average earned creditor put down on their claim form besides just the claim for the coins?
Yeah, great question. I've spoken about it. The judge has made it very clear in the January 4th decision that, with respect to earn, it's property of the estate. But there are claims. That doesn't mean you're not getting anything. You still have your claim back for crypto. And he made it, the judge said it over and over again in the decision that he's not making a ruling on, the claims, the affirmative claims of the borrowers, of earn or any crypto holder. Those claims are obviously fraudulent inducement, right? Which is laid out in one of the pleadings recently that was filed about what one needs to say to state a claim for fraudulent inducement. Violation of securities laws, right? If earn is a security and it's being sold, that was a violation of U.S. securities laws. RICO, nobody's mentioned RICO, but clearly there's, that claim is floating around here. Consumer laws, right? Every state, New Jersey has a very, very strong consumer fraud statute, and as do most of the other states. But New Jersey is particularly strong. Failure to obtain necessary licenses. Okay, so Celsius is operating, its business in all of these states without licenses. They not only don't have lending licenses, they don't have money transmitter licenses, and those are pretty much required in every single state, and the remedy is different, depending on the state. In some states, when you get a money lender license, you're supposed to have a surety bond behind you, which I guess sort of explains why Celsius never got state money transmitter licenses, because they would have had to have basically gotten a bond, behind that money transmitter license. Those are just a few of them. Literally you can go through, tort by tort, and look at, every type of potential claim. Breach of fiduciary duty, I forgot to mention that. The company was insolvent. They continued to do business and misrepresented, the status of the finances of the company. Breach of contract, right? The contract says that you're entitled to get your crypto back, when you ask for it. They couldn't comply with that. There's literally every type of claim under the sun that you can assert. Now, I think that from the borrower's perspective, we're going to be asserting a lot of those claims. And, I know that 99% of the people here are not lawyers. We'll try and, sort of convey, although it's not legal advice, we'll try and convey some of the information to the Twitter to Twitterverse.
First question, which I think other people might have, part of that is that if your coins are correct, but you want to file an additional claim for some of the things you mentioned, do you have to rewrite down your coin amount accurately?
Yes.
Or is it something that you just, okay, so that's question number one.
Stop. So important point. If you do nothing, if you do not file a proof of claim, what the debtor has scheduled you as, assuming they don't dispute the claim or say it's unliquidated, what the debtor schedules you as is your allowed claim. Okay? If you do nothing. If you file a claim, you supersede that scheduling. So if you file a claim, you have to list the crypto holdings, or else your claim could be deemed to be superseding the schedule, and you may lose your claim for crypto. Very important point.
Great. I'm glad that you answered that. And secondly is, in addition to all these, these you mentioned, right? Every law under the sun could have potentially been broken by Alex and his crew. Now, I also understand that the UCC is doing their own part that kind of told me that, hey, you don't need to do anything. We're going to go ahead and create a trust that's going to be for the benefit of all of our creditors, and any type of anything that we can get from either if there's an insurance policy for Mashinsky, or whatever there may be, whatever claims that may be ready for damages, that would go into this trust, and that this trust would be distributed equitably towards the creditors. Is that accurate? Is that correct? And then also, if that is correct, by doing this, are we just propounding the problem, creating more money for Kirkland and Ellis to go through these files? Like, do you understand? Do you get my question, or should I be a little more specific?
Just a little bit more specific.
Yeah, David, how is a litigation trust typically funded so that the lawyers can pursue all the litigation?
Right.
So is the litigation trust something that's to our benefit, that allows us to kind of sit back and say, okay, the UCC is going after any type of fraudulent inducement, going after any type of claims that they have, is going to make sure that New York Attorney General that filed this claim against Mashinsky and company, whatever proceeds they get, we're going to try to make sure that doesn't go to the state of New York, but instead goes to the creditors. Is all that hogwash and just kind of fantasy? So we should definitely go ahead and file these claims separately? Or is that accurate? And then by us individually filing these claims in addition to what the Celsius UCC is doing separately is just increasing the time and cost of the proceedings?
I think that ultimately the money that is recovered, whatever money is recovered, that the litigation trust is pursuing, will go to for the benefit of creditors, not necessarily the state agencies or regulatory agencies. I think they'll end up being subordinate to the crypto creditors. In terms of the civil action that was filed against Mashinsky, that's probably going to be roped in somehow. I see that sort of being determined. The claims against Mashinsky being determined with the claims of the creditors as well. And if you're asking me whether the states can jump over the creditors, my answer is with respect to third parties, my answer to that is unlikely. It's unlikely.
But I just want to be clear, because I think this is important. So what I'm asking is, if the Celsius UCC and the trust is already filing these civil claims against Mashinsky on our behalf, why should we do it again and file it individually? Does that increase the cost to the court, the attorneys? Why is that something that we should be considering if Celsius UCC already told us we've got this under control and we've got your best interest at heart?
The answer is a complicated legal one, but let me break it down and try and explain it in simple terms. The answer is you should be filing direct claims, okay? Because right now the estate has claims against Mashinsky. And if they were to assert those claims tomorrow, if they were to file a complaint against Mashinsky tomorrow, the Mashinsky would raise a defense, which is a Latin defense called in pari delicto. It basically means equal fault. And what it basically does is it's a defense that says if the person bringing the action is equally wrong, committed some wrongdoing, that person is precluded from recovery. So if Celsius sues Mashinsky saying, you committed fraud, Mashinsky might come back and say, Celsius, you are stopped. You cannot recover from me because of in pari delicto. Okay? If you file a claim against Mashinsky, and if the plan provides that you, as part of the mechanism to get your recovery, you assign your claim to the liquidating trust. If the liquidating trust pursues your claim and the 50,000 other people who have the same type of claims against Mashinsky, Mashinsky can't raise the defense of in pari delicto. Does that make sense?
Against the individual. But against
Correct.
the UCC estate, they could. Now, let me ask you, but the dirty hands doctrine, wouldn't that apply to us as individuals? Because clearly we were engaging in a company that was doing illegal conduct.
No, I mean, really, in pari delicto is like two wrongdoers suing one another.
Gotcha.
And whereas, here we have innocent, retail customers who got swindled, right? And there is no in pari delicto defense, if you have a direct claim against Mashinsky. Whereas if Celsius is bringing the action on behalf of the estate, that defense will be raised. And there is a considerable body of law in New York on the scope of in pari delicto. And, in many cases, it precludes recovery, which is one of the reasons why I've been saying that individuals should file claims, because I have this vision that all of those claims will be assigned to the liquidation trust. And when they get prosecuted, you won't have to worry about that defense being raised by the defendants.
Gotcha. So they'll take our claims into the trust.
Correct.
That will bar him from being able to argue that it's an estate.
You got it.
It's a bunch of individual claims. Gotcha.
You got it.
Perfect. Thank you, David.
Do you know the process of how would it be the debtor denying claims? Like if you submit it incorrectly the first time, is it just denied, or did they reach out and ask for more information, like supporting information or something, and then they deem it?
Yeah, so I mean, generally what happens is, I mean, this is part of the reason why the fraud claims and let's call them the tort claims, create some messiness in the case, is when you put those claims in, the claims are unliquidated, right? I mean, you can put down 10 million, whatever number you come up with. The bottom line is those claims are disputed and they're unliquidated. And they're contingent as well as upon a finding of liability. But generally what happens is, a plan is confirmed, and then the claims objection process starts. They don't write you a letter saying you're like in class action suits saying your claim is denied, or you're, sorry. I mean, if they have a problem with it, they can object to it, and that creates a contested matter in the bankruptcy court, which is sort of like a mini trial, and at that point you can put forward your proofs, and they can put forward their defense. There's going to have to be some type of streamlined process for dealing with the tort claims here. Because you can't have, 300,000 people alleging fraud and trying to liquidate those claims. There's going to have to be some sort of, phased process where, the people who asserted like fraudulent misrepresentation claims are all grouped together, and the court sets up a schedule for dealing with the determination of that claim. It's going to have to be a process whereby everyone's who asserts these types of claims gets put into a certain type of program to prove their claims.